Mistake number 4 is assuming that since your employer said that you were too sick to work, that the disability insurance company will share the same opinion. Whether you or your employer purchased your insurance policy, in almost all cases, the disability benefits you may be paid come from the insurance company. Make no mistake, it's the insurance company and not your employer that determines when and if you meet the legal definition of disability under the terms of your policy. I've seen cases in which the employer refused to allow the employee to return to work without the approval from the doctor, and even agreed with the doctor that the employee was unable to work. But the long-term disability insurance company still wouldn't pay benefits. How can this be? The answer is that most insurance policies insure your occupation, not the job you hold. In other words, while you may not be able to perform all of your job requirements that your employer expects you to do, you may still be able to perform the substantial and material duties of your occupation. My law firm represented a beer route driver who sustained a brain injury. Since he couldn't deliver the merchandise because he couldn't remember the route, he was placed inside the beer distributorship to count bottles. A long-term disability carrier denied his claim, in part because they maintained he was able to perform the substantial and material duties of his occupation. You can avoid the mistake of assuming that your insurance company will share your employer's opinion about your condition. If you read your policy, you have to determine what the legal definition of disability is that applies to you. Is it the inability to perform your specific job, your job as you performed it for your employer, or your job as performed in the local or even the national economy? Once you understand the standard of disability that applies to you, you should then ask your doctor to address your ability to perform the physical or mental requirements of your job, or even the material and substantial duties of your occupation. Simply asking your doctor for a note that says you're disabled won't do it. Your physician has got to address the material and substantial duties of your occupation, or whatever the applicable standard of disability is in your policy.